Presentation from the town attorney on mobile home rent stabilization and perhaps provide staff with next steps. Do we have any council member conflicts that we'd like to announce?
I do have a conflict of interest as I'm a proud resident of Rancho de Napa, so I am going to recuse myself.
All right, we will come get you when we're done. Thank you.
And Hillary, you're telling me the clicker's not working?
It appears a PDF was attached instead of a PowerPoint. I'm here to help.
That's fine. I'll just tell you when it's ready to go to the next slide.
Thank you.
No problem. We don't need to stay on the title slide anymore. The next one. Great. All right. Well, let's start with some nomenclature. There is lots of terms of art in this area of the law, and I have tried to avoid most of them. Mostly because today we're giving a high-level presentation on concepts. What is this? What is this not? So that you all can give direction to us on whether or not you want to pursue this, either by gathering more information or by giving us direction to do something in particular with an ordinance. So this presentation is not meant to be comprehensive. That would be a much longer meeting, much longer than the 30 minutes or so that I'm going to present to you now. But it does cover the major requirements and then what these ordinances tend to look like, what's included in them, what's not included in them, and then how some other jurisdictions do it. Enough to give you information to give us informed direction on what steps you'd like to take next. So first on nomenclature, we've heard about rent stabilization versus rent control. Both of these concepts do similar things. Rent stabilization seems to be the term that is more recently used, so we can use that if we like here. But both are regulating rental prices and limit the amount and or the frequency that rent can be increased, and might include other procedures for how that rent increase takes effect or how it's implemented by the landlord. Next slide, please. So mobile home tenancies. These are different and these are unique. They are not like and not treated under state law like tenancies for single-family homes or multifamily units that you have here in town and that every other jurisdiction in the state of California has. The California Department of Housing and Community Development, what we refer to as HCD, oversees these parks in a way to insulate them to a certain extent from local control and regulation. Not all of it, but some of it. So HCD has a large role in overseeing mobile homes in the state of California, including the ones here in Yountville. But these are treated differently than other residential tenancies for that reason. And they're treated differently under the three major laws that we'll talk about today. The mobile home residency law, that lives in the state civil code. Same with the Costa-Hawkins Rental Housing Act. And then the Tenant Protection Act. These are all civil code provisions. Civil code has lots of provisions governing landlord-tenant relationships, both in the commercial context and also in the residential context. And there are very specific provisions for mobile homes that we'll talk about here in just a moment. Next slide, please. So what is the mobile home residency law? It regulates rental agreements, what's in them, what can be in them, how you do them, rules enacted by park management. Anyone who's ever lived in or visited a park knows that there is a set of park rules. It usually lives on the park's website, and there are copies available to residents and their guests. Termination of the tenancy and how you do that, and then authorizes fees and charges that can be passed along, including things for common charges and common spaces, but also for utilities. So some parks might have a master meter, and I know that's true for some of the parks here in Yountville. And so how do you pass those costs on to all of the residents when you have a master meter as opposed to individual meters? So there are provisions in the mobile home residency law that cover all of that, and that's what the mobile home owners follow for administering all this. For those who are not as close to this issue as some here in the room, the mobile homes tend to have a ground lease with the mobile home owner. So the home itself is privately owned by someone, and they are leasing the ground underneath it. They're not leasing the structure itself. And that is different than how most rental arrangements are in the residential context. If you go to rent an apartment or you go to rent a home or a single-family home, you don't own the thing that you are renting. You are renting the right to occupy for a period of time under certain conditions. In this case, the mobile homes are typically owned and you are typically leasing the ground underneath, what's referred to as a ground lease. So there used to be exemptions for quote-unquote new construction after 1990 from local mobile home rent stabilization laws. That was recently changed. It's now new construction for the first 15 years of construction. Next slide, please. It generally does not restrict initial base rent or rent increases, the mobile home residency law, that is. There are other laws that touch on this, but not this one. Silent on those. The market, of course, plays its part. There's a limited exception. It imposed a 5%, AB 978 imposed a 5% cap on rent increases in qualifying mobile home parks, but those had to be located and governed by the jurisdiction of 2 or more incorporated cities. And I have a feeling that that was a very specific law for maybe 1 or only 2 mobile homes. And of course, that doesn't apply to us here in Yountville. Next slide. Costa-Hawkins Rental Housing Act. This is a state law that was passed in the 90s, and it was meant to protect new construction and exempt new construction from rent control ordinances, which were starting to take off. We'll talk about the case law in a moment that started in the 70s and started to gain more traction after. But it was a state law that preempted it preempted the local ordinances that conflicted with it. And so this state law was passed. At the time, there were different terms, and I promise these are only the additional 2 terms of art I'll use, but it prohibited municipalities, and that's you all, from adopting new vacancy control ordinances. And there were ordinances at the place at the time that required new tenancies to be subject to the prior tenancy's rent. So if a unit was vacated, the new tenant had to be charged the rent of the tenant that had just left. There was no ability to change it or bring it up to market rent or market rate. So those are now prohibited under the Costa-Hawkins Rental Housing Act. But it did establish vacancy decontrol, which allows market rate adjustments to new tenancies. So if a unit that is subject to rent control is truly vacated lawfully following the ordinance and also the Costa-Hawkins Act, it can be reset at that point, unless there's some local, there are some exceptions to that rule, not relevant here though. It exempts units that are first occupied after February 1, 1995. In other words, rent control can apply to older units before that date, but it can't apply to new units after that date. But it expressly does not apply to mobile home tenancies, so that exempts it out. So I mention it here because this is the other major rent control state law that is out there, and it's sometimes confused or thought to apply to mobile homes, but I give you this background as we go to the next slide. The Tenant Protection Act in 2019. This was the state law that put in rent control for certain units, and then also just cause eviction for certain units, meaning can't evict for no reason at all. If the unit is subject to that, you have to have a specific reason that's outlined in state law. This was a major sea change when it took effect in 2019. It limits rent increases to 5% plus the CPI, or 10%, whichever is lower. And if the math is confusing you, it is a little confusing. You kind of have to follow through and add it up and figure out whichever one's lower. It does regulate how and when a residential tenant can be evicted for just cause. So you have to have a reason. It could be violating the law, breach of some term in the agreement, creating a nuisance on the property. There are a few others that are specified there. It does apply to some, but not all, mobile home tenancies. So I mentioned earlier in the presentation, typically the mobile home is owned and you are leasing the ground beneath it for a ground lease. But the owner of a mobile home can also lease the mobile home. So in some circumstances, the owner might lease out to a tenant the mobile home and then still have a separate lease for the ground with the mobile home owner. Under those circumstances, it is a rental, quote unquote, that is subject to the Tenant Protection Act and these sorts of caps. It's not the typical arrangement, but there are some mobile homes that are rented out that this would apply to. So I mention it here. Local jurisdictions can adopt stricter protections. There are, particularly here in the Bay Area, there are jurisdictions that have adopted their own local tenant protection laws. If you adopt a local one, it completely supersedes the state law Tenant Protection Act. This is strange. This does not usually work this way. Normally, state law preempts everything, and whatever wiggle room they give you is what you can regulate in. This has flipped it on its head. They wanted to make sure that locals had the ability to go further as long as you provide an equal or greater amount of protection to the locals, to the folks in your jurisdiction. You can adopt your own local tenant protection act or ordinance that would supplant these state law provisions. So as a default in state law, you can adopt your own that would do away with the state law provisions as long as you find that it's at least as protective as the state law. Next slide, please. There are approximately 104 jurisdictions, and I know that we have some folks from the trade groups here, and they might correct me on that number, but I believe there's 104, but I put approximately in there just in case. 104 jurisdictions in California have adopted some form of mobile home rent control. For those of you following the news, I'm sure you've seen the controversy just over the hill in Sonoma. That's related to their overlay, not rent control in particular, but it is common. In many jurisdictions, mobile homes are one of the only, and in some the only, affordable housing stock that are there. And so preserving that and keeping it affordable to a certain income group is something that a lot of communities find necessary and do. Not all, though, but some. Next slide. So what do local ordinances typically do, and what do they not do? You will sometimes hear about rent boards, and Councilmember Tripp, I don't know if you were on a rent board. I'm seeing the head shake, so she might have more info on that. I think there's only 9 or 10 rent boards in the whole state. There's not a whole lot of them, and mostly on the coast and not inland. So some jurisdictions will create a rent board that will actually hear these disputes. Disputes between landlords and tenants over the ordinance and rent increases and the terms of the lease agreements and the like. But not all jurisdictions do this, and in fact, the ones that create it are sort of the odd ones out, not the ones that don't have it. But there are rent boards out there, and you will sometimes hear that term, but not all jurisdictions do it. So local jurisdictions often include some combination of the following: a percentage cap on rent increases. That could just be a straight percentage, no more than 3%, no more than 4%, et cetera, or a percentage and a CPI. So you saw what the state did in the Tenant Protection Act, 5% plus CPI, not to exceed 10%. So some combination of math like that. But they also include a process for park owners to petition to exceed that cap to ensure they can receive a quote-unquote fair return on their investment. That's required by judicial decisions here in California, which we'll talk about in just a moment. And then a mechanism to pass through utility costs. The mobile home residency law already includes a process for passing along utility costs, but some ordinances will go into more detail about what that looks like and common charges. Think about common areas that are used in those costs and how they're allocated. A framework for tenants to dispute rent increases or agree to increases that exceed the cap. Some cases, maybe you have all the tenants in a park that say, well, we do want to pay more because we want this new infrastructure or this new benefit or this new thing that's being provided. So it allows for agreements and some process to exceed it if everybody seems to agree. And then advance notice requirements before rent can be increased. There's usually you can increase it within a certain window, provided you've given notice within a certain window. It's a common provision that you'll see in these ordinances. Next slide. All right, now for some case law. So this one's from 1976. It's a California Supreme Court decision. It upheld the city of Berkeley's power to adopt a rent control ordinance. This was a question. Could Berkeley do this? Is this unconstitutional? Does a city have the ability to do this? I'll note that Berkeley is a charter city, so they have a little different authority than Yountville. But nevertheless, the court found that, of course, you can adopt an ordinance that places burdens on landlords. That is the essence of regulation. That's the essence of the police power. You can regulate things, and that does create burdens. When you regulate for the greater good, people who are regulated do incur some burdens. Next slide. This next one, see, this is the Santa Monica Rent Control Board. They're one of the ones that had one and probably still do. This is the one that gives us the real test, the legal test for how we're going to create a enforceable and constitutional rent control ordinance. The laws must be reasonably calculated to provide landlords with a just and reasonable return. The reason for that is most of the challenges around rent control are over a takings claim. So you know the federal constitution and the state constitution says the government can't take private property without just compensation. There's a process for that you have to follow. So when the rent control ordinances went into effect, the owner said, well, you're preventing me from making the profit I want or charging the rent I want, and this is a taking. Right? So the court said it's not, provided it's reasonably calculated to provide a just and reasonable return on their property. They own the property, they have a right to make a return on it through their investment. In order to satisfy that, rent control laws incorporate any variety of formulas to calculate rent ceilings, but there is no standard formula for doing this. So the court refused to say this is the one way you can do it and there are no other ways. You can come up with your own way as long as it is reasonably calculated to provide the just and reasonable return. Next slide. You cannot indefinitely freeze rents. Why? Because you have to provide a just and reasonable return on this property. So you couldn't say rent is what it is today and it shall never go up again. There has to be a process to increase it over time. And there also has to be a release valve for the owner to receive that just and reasonable return. So what you will see in the ordinances is rent is set at a certain amount. Maybe it's what it's being charged right now. It goes up a percentage over year. But the landlord can still petition to exceed that as long as they can show and provide evidence that they're not receiving a just and reasonable return. And that release valve process is a process that's included in most of these ordinances. So allow adjustments in appropriate cases. If base rent is tied to a specific date, it allows adjustments for units with artificially low rents at that time. And so this provision is important to note here, the second bullet point there. I don't know if the rents currently here are market rate or if they provide a just and reasonable return. I don't know the answer to that. If you impose rent control at a certain date, the rent can be increased to make sure that they're getting that fair and reasonable return before it takes effect as well. In other words, you can't freeze in the artificially low rents that are in place. And so it is possible, at least under some circumstances, the rent would go up temporarily when you are putting in place a rent control ordinance in order to capture what that second bullet point is referring to. Procedures to obtain a rate adjustment must not be prohibitively burdensome or cause more delay. So you can't create a 4-part appeal process with 2 hearing officers, right? You have to have a straightforward process to challenge this that is possible and reasonable. And then landlords should not have to prove building code compliance for an adjustment. In other words, you can't condition that adjustment and fair return on some sort of compliance issue that might be there. You have a process for code compliance, you can follow it. You have a process for rate adjustments, you can follow that too. Courts are not going to allow you to tie the two together. Next slide. So here's the key takeaway. You must still provide for a just and reasonable return. This is private property. They are investors. They are entitled to that. You can presume that the landlord's net operating income at the time of rent control provides a fair and reasonable return and then adjust, but landlords need a mechanism to exceed that if they can show that they are not receiving their fair return. Next slide. So what does this look like to administer the ordinance? Ordinances, there's a sliding scale here. On the one side is the rent control board that I talked about, which is very involved, has a separate body that you create, and is very administratively burdensome. Those rent control boards typically have separate attorneys, separate designated staff. It's a big operation, typically reserved for much larger cities. On the other side of that spectrum is an ordinance that caps it and provides certain rights to private litigants, but really doesn't have much of a local jurisdiction's involvement, right? But like any law, if you are the receiver of the benefit or the burden and it's being breached, you can sue to enforce that. And so A local ordinance has the same force and effect as a state law, and so you can create remedies in the ordinance and folks can go and enforce it. That's the other side of the spectrum. In the middle between these two poles is a wide variety of options, and ordinances take a lot of different iterations on how much involvement town has. It would be expected that town staff would receive lots of questions from landlords and tenants, right? So even if you don't have a particularly active role, tenants are very likely to be calling town staff. It's a town ordinance, asking them, what does this mean? Is this allowed? How does this work? Many jurisdictions create a process for that, or process for submitting questions. Landlords will submit petitions for additional rent increases. So if they want to say, I'm not receiving my just and reasonable return, here's all my evidence, they're going to submit a petition. Typically, that's heard by a hearing officer of some kind, which then reviews all the evidence and the town's position and then issues a decision under the ordinance on whether or not that standard has been met and rent should be allowed to go above what the rent cap is. There are procedural complaints, substantive challenges to rent increases from tenants, appeals after a rent increase petition is approved or denied. Those appeals could go to the town council. They could also go straight to court after a hearing officer, if you set it up that way. And you may designate staff or appoint an outside hearing officer, as I mentioned. You can require the petitioner to pay the cost of a hearing officer, and you can adopt a fee schedule for that process too. And then you can continue to enforce code violations. The other costs that are associated with this, adopting a rent control ordinance is not without risk. You've read about that in the news. There are other jurisdictions that are currently facing legal challenges too. Next slide. So how do we resolve disputes between them? You can allow landlords and tenants to submit settlement offers to avoid hearings. A lot of ordinances will do that. If there's some sort of dispute that triggers your hearing process, allow them to settle this. If it's not settled or accepted, the rejecting party fails to obtain a more favorable decision, then you can shift legal costs. And that's a concept borrowed from state law that many local jurisdictions have put into their ordinances too. You can provide a hearing process for resolving tenant claims. The landlord has violated the ordinance and etc., but you're not required to do that. That hearing process would be administratively burdensome for the town, even if the costs were covered by others. Next slide. So here's some practical considerations for dispute resolutions. Hearing officers need to be neutral. They need to be free from bias. They need to have no connection to the circumstance. So there are companies that do this. There are law firms that do this. There are non-lawyers who do this. The other circumstance where this comes up is for code enforcement. Your ordinance provides for code enforcement appeals to go to hearing officers, and that does happen occasionally, but doesn't happen very often. You need to have a hearing officer who understands spreadsheets and financial documents, and that might be why you shouldn't pick a lawyer. But there are people who do this, and so you need to find someone who is understanding these documents to issue a decision. There's some administrative burden and cost for education and outreach and community input. It usually lives in the planning department, so Aaron's team would be in charge of some piece of this in education. You can create template notices and forms and cost recovery agreements and put them on your website to make it a little easier for the tenants and also the park owners. Throughout this, we have to ensure adequate due process. That's why I was talking about having a neutral third-party, unbiased hearing officer to hold the hearing. And then there are some takings claims issues here if they're denied their rent increase. That's always out there. And then there's some town involvement in civil disputes. If your ordinance is creating a hearing process where you have a hearing officer, that hearing officer's decision is what would be challenged in court. Even if the real dispute is between the landlord and the tenant, the town's hearing officer issued a decision, that's what would be challenged. So it's very likely that the town would be named in any kind of dispute under that sort of arrangement. Next slide. Next steps. We're here to receive direction from you all, whether to proceed or gather additional information or come back with more information or perhaps a longer presentation from staff. But as an initial step, it's likely worth gathering more information for the need for rent control or rent stabilization here in town. And certainly we could do that if we got the direction in the meantime. And with that, I'm happy to answer any questions.
Okay, I'll give a kind of brief explanation about how we should probably proceed here. So first, the council can ask Gary or staff or Director Heacock back there any questions. Then we'll take public comment. You can come up and give us your opinions, and then we'll bring it back here for possible direction to staff. So with that, who would like to start questions first? Councilmember Tripp?
Actually, one pretty simple question, although I did want to say I did serve on the Oakland Rent Board, which was the quasi-judicial hearing body for appeals from the administrative hearing body, and then if they were unhappy with us, then they did sue in court. But I was a neutral representative, so I was a homeowner, not a tenant or a landlord. So I have had, I think I did that for about 3 years, and it was the height of public service because it was really hard. They're just tough things to to decide. But anyway, my question is, I just wanted to be sure because it's important, and I was kind of surprised when I started investigating this, that the Tenant Protection Act, unless you're renting a mobile home to somebody, which I think for the most part in the 2 parks in Yountville, that's not common. I think in Yountville it's ground leases for the most part. So that really doesn't apply to our situation unless through some unusual grouping of events somebody was actually renting their mobile home.
That's right. The Tenant Protection Act, under those facts, you're right.
Okay, so we could kind of take that off the board. Mm-hmm. And then the first one you mentioned, the mobile home residency law, doesn't really, and again, I was kind of surprised by this because I know regular tenant, but not this, doesn't really govern rent increases.
No.
Except in that one group of.
Yeah, except for the one mobile home that probably meets the definition that was there in the mobile home park. The only exception to that, it exempts homes that are not primary residences from local rent control ordinances.
Okay.
If you follow that piece.
I do, and that was my exact question.
Okay.
If Yountville wanted to be more stringent on that point and say we're going to pass something that covers units that people are living in full-time versus non-full-time, could we do that? We would be being stricter. I'm sorry to interrupt you, but that would be...
No, that's okay. I'm not sure that the town can. We would have to look at, it's a preemption question. Certainly under the Tenant Protection Act, you can go further, but that doesn't apply here. And the mobile home residency law, I would have to look at that question specifically.
Okay,
Yeah.
so that's sort of an open issue. Okay,
Yeah.
Thank you. And I do have some views on this, but I very much first, and I think this is what the mayor said, first we should ask questions, then hear from the public.
Councilmember Knight, you have questions? Councilmember Reeves?
No, I'm going to listen to the public.
Okay, so I do have some questions. So really, well, back to the mobile home residency law. Years ago, when we were reviewing one of our housing element, it kind of struck me that we really didn't have a 55-plus overlay. So I brought it up, and that's now the law of the land here in Yountville. The rest of the council agreed that that would be an extra protection. So I spent a lot of time looking at the mobile home residency law, and I've have now found that almost a new one comes out almost every year. So if we have an ordinance that covers something, do we have to update that? Because sometimes things change a little bit, and sometimes things kind of change a lot. But I would imagine that we do. Because I also, when I called the state and asked them about that, they actually asked for the names of the 2 parks I was referring to, because they said not all the parks actually fall under the mobile home residency law. And it was a long time ago, and I can't even remember why, but they had to look them up. So
it does change.
Okay.
And the provisions, there are lots of provisions in there that govern leases and how and when the tenancy started, and some it's when it was constructed, and those things do change.
Right.
And there's current proposals right now, so the exception that I just mentioned about if it's not your primary residence, it's not subject to local rent control, that is being proposed at the state level to change. There are bills right now circulating
Right.
to change this. So to answer your question, like any other ordinance, and for those of you who sat through the 10 or 12 ADU ordinances that we've done over the last 10 years, you know, state law changes, we're going to have to look at this and probably revise it over time and continue to track it and monitor it, just like many other ordinances in the zoning code or elsewhere.
So probably more staff time.
Yes.
And that kind of answers my other question, because I haven't really seen it in the most recent ones, but life is changing a lot, especially in Yountville, in terms of second homeowners. And so that is not yet law then. That was my question, that we could put something in the ordinance that applied to primary residents versus second homeowners, or is that something that maybe I should keep adding to my long list of questions?
Yeah,
that'll come
you're
up
saying,
later.
could we adopt a local ordinance that applies the rent control to second and third homeowners?
Even though the
as
state
well?
hasn't done it yet.
Yeah, I would need. I do. I would need to look at that preemption question. I did not research that specifically for this meeting, so
Okay.
hesitant to give an answer. But I would take a look if that was the direction.
Okay,
Yeah.
so put it on my list of my questions for later. Another question, you mentioned the fair and reasonable return. That's been puzzling to everybody for a long time. So would that be something that we would look at other ordinances, or actually do a study, or any thoughts on how we would attempt doing something like that if we needed that information?
Yeah, you can. The case, one of the cases that we mentioned, when it says you can assume what they're currently charging and in there is a fair and reasonable term or return. You think about it this way: folks who are in business typically don't run a loss, otherwise they wouldn't be in business for very long. So if they're currently running a business, it's reasonable to assume that they are receiving the return that they would expect, or that the market allows, or that they want to receive on that. That might not be true for every unit, right? There might be one reason or another why certain units in the park are below or artificially low, and there needs to be a process to bring those up when your rent control comes in. But you can assume, because they are running a business, that what they're currently charging is roughly a fair and reasonable return. Your ordinance will also have a clause in it that says, if you're not, here's your process for proving it up. And so after it takes effect, an owner could come in, show their financials, and say, here's what it costs now. And that could be because there's an increase in cost that can't be passed through, or some other changed circumstances. So it's not a science, but we have a pretty good metric because we know they're running a business right now. And so they must be receiving at least a return that the market's allowing.
Okay. So I have one more question, and we'll go to the public comment, and I have other questions later, which I'll save for later. So we have 2 mobile home parks in town, and so if we pass an ordinance, they could apply to one or the other or both. We don't have to, like houses around here, we say, if you have a house here, this applies, and so we don't say this neighborhood versus that neighborhood.
Right.
But if we have 2 mobile home parks, what's your thoughts on that?
So if the council's desire was to apply one to the other, we would need to distinguish, because laws are generally applicable. We can't pass a law that singles out a particular business or company by name. It would
Right.
need to be a generally applicable law. But generally applicable laws could also say parks that meet the following description and so on are subject to this. And that, I'm not suggesting that go there, but there are ways to do a generally applicable law that applies to all of a certain class. But generally speaking, you would adopt an ordinance that would apply to mobile homes generally.
Okay. General applicable law, so we'll talk about that. Applicable. Other question, Vice Mayor?
So the overlay question, it seems that some of the mobile home park operators are litigating just even the overlay, let alone any kind of rent stabilization. So would you say that a rent stabilization could provide extra protection for the mobile home parks if the overlay is questioned or removed?
I think that they provide two very different things. The zoning code overlay restricts how the property can be used, what can be done on the property. And so if you think about the overlay that you have here, if one of these owners wanted to sell to a developer that wanted to bring in another hotel or any other use on these properties, your overlay does not allow that, right? And so the overlay ensures that these uses continue as these uses. I'll note that there is a process in state law for when you are selling and shutting down the park and you have to buy out the current tenants. It's very expensive. So I don't want to create unnecessary hysteria here. There's a separate process that is cumbersome. I'm only talking about the town overlay. But the town overlay is really a zoning code function for use of the property. The rent stabilization or rent control ordinance serves a very different purpose, which is what the landlord can charge. And that's just a separate question from the use or what can be done on the parcel. Yeah.
I forgot one more quick question I had. So then I promise we'll go to the public because I know they will have a lot of opinions and thoughts. So there was quite a few things, I won't go into the details, about needing staff to interpret ordinances, and people come in, maybe being something like a rent control board and, hearing officers and things like that. So how is that compensated? Can we compensate? I know we can only charge for actual. We can't make any money on this, but we can charge for actual staff time. Is that typically something that municipalities do to when these things get enacted, or?
Yes, if locals choose to have a hearing officer or some dispute resolution process that the town is going to administer, and that's not required. So you could adopt an ordinance that just has the requirements, and then folks would need to enforce it on their own. Like a lot of laws, you'd enforce on your own in the courts.
Okay.
But if you create an internal process for dispute resolution with a hearing officer typically, yes, you can pass those costs on to the landlord and also to whoever's filing the petition for the change, right? So you would charge the cost of the hearing officer, the town costs associated with that, and you can also adopt that into your master fee schedule as well if you chose to go that route.
Okay, so the fees that way could also change every year. Okay, I'm going to open up public comment. Who would like to come up and give your comments to the council? I know there's people out there, so I'll wait for the first brave soul who wants to come and address us. And we have 5 minutes, and you can kind of see the clock on the screen. So,
hello, my name is Jennifer Rassler, and I live at Bella Vista Park. A rent stabilization ordinance, not rent control, is a proven local tool for helping preserve affordability and prevent displacement of mobile home park residents. Rent stabilization protection is available for people who live in mobile home parks in more than 100 towns and cities in California, such as our neighbors as Calistoga, American Canyon, Windsor, Petaluma, Novato, and Santa Rosa. I urge the Town Council to respectfully move to issue forward and adopt a rent stabilization ordinance for both mobile home parks in Yountville. This is a practical and necessary step to help seniors age in place, protect affordable housing, and keep long-term residents from being pushed out of their communities. This is a place where I hope to age with dignity. I thank you for your time.
okay, thank you.
Hi,
Excuse me. Hi.
Can
Good
you just
afternoon.
move the microphone close to you so we can get you
When you're a
on?
midget, that's what
Okay.
happens. Good afternoon, Council, Mayor. My name is Peggy Ahrens, and I live at Bella Vista Park also. I strongly support a rent stabilization ordinance for the Yountville mobile home parks. Our town needs a clear plan to protect affordable senior housing before residents could be priced out. Many seniors live on fixed incomes, and when space rents rise too fast or too frequently, folks can lose the ability to stay in their homes and the community they know and love. Thank you. I humbly ask for your consideration.
Okay, thank you very much.
Hello, my name is Jeffrey Lake, and I live in Bella Vista Park. Good afternoon, Mayor and council members. I serve as president as one of the founders of Bella Vista Chapter 388 of the Golden State Manufactured Home Owners League. We organized in January of this year, and our chapter continues to grow. Presently, we have 47 members and is growing. Today we received a briefing on portions of the legal big picture regarding the history of rent control and rent stabilization in California. For the next action steps toward creation and adoption of the Yountville RSO, your mobile home parks, we asked staff to study the Petaluma RSO, which recently has been tested, revised, and enacted, and as well the San Rafael RSO, which passed mustered all the way through appeals to the United States Supreme Court. These ordinances are two examples from nearby communities that can shorten our local learning curve and enable us to obtain a rent stabilization ordinance that meets the needs of senior mobile home owners and protect the right as well of the park owners. Today, our ask is simple. Please enact an ordinance that is modeled on a well-designed, established models that won't be needed to run through a grinder of prolonged and costly conflict and litigation to accomplish revisions and fine-tuning. In addition to learning from the ROSO experiences of neighboring jurisdictions, as the next step, we urge the council to further direct the staff to facilitate local stakeholder engagement meetings so that we may obtain a more accurate assessment of what is needed to preserve and protect the remaining stock of existing, affordable, unsubsidized senior housing in this town before more units are converted into part-time vacation homes. We appreciate your attention and your actions that will save our existing affordable senior housing, and for your continued leadership toward adoption of a well-crafted RSO for Yountville seniors who own their homes as their principal residence in both local parks. Rent stabilization is not rent control, and we are not tenants, we are home owners. They are not landlords, they are park owners. And as unsubsidized principal home owners, we vote. Thank you.
Thank you.
Good afternoon, council members and mayor. I am Robert Noakes, a resident of Bella Vista Park here in Yountville. And I'm asking that the town council protect seniors in Yountville who are living on fixed incomes and are worried about whether they can stay in the place they will call home. For many older adults, I scrolled accidentally here, 1 second. For many old adults, a mobile home park is not just housing, it is safety, routine, neighbors, and connection. When space rents rise too much or too fast, seniors can face fear, stress, and the real risk of losing the community they depend on. Moving the mobile home they own out of the park is too costly or simply not possible. There's no place to go. A local rent stabilization ordinance, not a rent control ordinance, distinction with a clear difference would be a fair and practical step to help seniors stay in the homes they own while respecting park owners' property rights. Please act now to help protect Yountville's remaining affordable senior housing that receives no government subsidies. Thank you.
Thank you.
Sorry, sitting there since 2:45. My sciatica has acted up. Okay, my name is Scott Greenwood Minert. Good afternoon, council members, mayor, and especially the town attorney. I am a local attorney here representing the owners of the Bella Vista Mobile Home Park. I would start by saying this. This town has the two nicest mobile home parks in the entirety of Northern California, and it's not really up for debate. There's a reason for that. This is a good town. The parks have good residents, not tenants, residents, and the town has good owners. My clients have owned businesses in this town for over 60 years. This is currently, I think, the last business that they own in town, but they have been here for a very long time, and they intend to be here for a very long time. Bella Vista strives to put its residents first and tries really hard to maintain a really nice park, benefiting a town like this, and more in particular, benefiting the residents. It's worth noting that a key component of park ownership, both the homes in the park and the park itself, is the protection of property values for everybody involved. Our park currently has a home for sale for over $500,000 in that park. So we're doing a good job. Rent stabilization, we'll call it that for the time being. Since 2020, the average rent increase in Bella Vista Park has been 4%. Some years a little less, more often than not 4%. 2023 was an anomaly. We should all go back and take a look at the CPI charts and inflation charts for our country and for our region for 2022 to understand why that rent increase was 8%. That year and in subsequent years, the park's insurance costs alone since 2020 have gone up 220%. I won't speak to the town's water and sewer charges. Effective 1/1/2026, the park put all of its residents on water and sewer meters for the first time. It is one of the very last parks in Northern California to take that step. It was done in compliance with the MRL. It was done in compliance with HCD guidance. And I would add, and this is perhaps probably most important, a week ago, after gathering metered data from all of the park's residents for the first 6 months of the imposition of the water meters, the park issued a letter to all residents stating that effective September 1st, 2026, their rent would be reduced by $72. That number was arrived at by looking at the comprehensive amount of data collected for 6 months and then creating an average for the rent reduction. That amount was not available because the park simply had not have any data as of 1/1/26 or the months before that, because all it had was 1 meter, and all the park did was pay that bill every time it came in. So with that said, I'm going to stop there and say this. I don't think, my clients don't think, that this is a rent stabilization situation. Rents have been stable in this town and reasonably applied for forever. My client has never passed through one under the MRL. As Mr. Bell pointed out to you guys earlier, there are pass-throughs available for certain capital improvements and things like that. My client's never done that, not once. And this client and his family have owned this for over 30 years. Hasn't happened. 3 years ago, they improved and repaved all the streets in the park at no charge to the residents whatsoever. That continues to be the case, and that will probably continue to be the case. So, with that said, I understand the situation. I understand the efficacies of rent stabilization. I'm just not sure that that's necessary here, and I would ask that you consider that there may be other opportunities outside of an ordinance to problem solve. Thank you.
Thank you very much.
Good afternoon. My name is Jody Johnson, and I'm a mobile home resident as well as a volunteer unpaid GSMOL vice president. In advance, we thank you for your consideration for a much-needed rent stabilization ordinance for the seniors here in Yountville. After decades of advocacy and ordinance enactments, I would like to bring to your attention some of the following details in your staff report. Certainly you are aware that mobile park residents and mobile park owners have a unique relationship. This is not regular housing or rental dwelling, as the resident owns the mobile home and rents the land underneath. This is truly the last bastion of unsubsidized affordable housing, where the residents themselves are supplying the affordable housing. California mobile home residency law governs the rules, rights, and responsibilities between mobile home park owners and resident owners for about 1.4 million residents in California. Rent increases, rules and regulations, leases and tenancies, dispute resolutions and help, and enforcement. MRLPP is the residency protection program to assist residents with complaints and helping resolve severe MRL violations. GSMOL has drafted, sponsored, and enacted many of the MRL laws. In 1985, 4 pages, to today, 77 pages of law. Rent stabilization is necessary to prevent gouging on the most vulnerable senior residents. While today's residents may not see, like he said, large investment orders seeking exorbitant increase, these circumstances can change quickly. They won't always own the park. Many cities and counties did not proactively defend, enforce, and strengthen protections, while allowing park owners to be the determining factor on how much is too much, because all was well until it wasn't. That imbalance of wealth and legal funding can lead to unfair business practices. Cited in your presentation, I don't need to go over, is Costa-Hawkins and tenant protection, which don't relate to mobile homes. They never have, except for a renter. Important to note that while a few mobile homes may be owned and rented, the vast majority of your mobile homes here in Yountville are not. Rent stabilization ordinance should include CPI or a percentage of the annual allowable increase. 70 to 75% is really what's been happening now. Rent cap no higher than 4%, although some jurisdictions are adopting 3%. CPI just came in at 3.8. Last year was a relatively low, but then, as he talked about in 2022, was very high. Important to note that in just one city, there were 7 arbitrations in just the last year. Once park owners accounting opened up their books, the arbitrator found that with 70% of CPI, that inflation had kept up with the profits of that park owner. Also important to note that out of all those attempted fair increase arbitrations, with an ask of as much as $1,530 more in ground rent, the award was 0. That's because the books did not support that they weren't making a profit. A method must be determined in RSO to prevent so many methods being used that residents are buried in legal debt. The standard held in our highest of courts is MNOI, Maintenance of Net Operating Income. This determines a base year and procedural accounting data. In the city of Windsor, with a substantial dollar ground rent increase asked for, with an arbitrator award of just $4. Any RSO must defend, enforce, and strengthen, and certainly close in advance the loopholes so that you won't constantly be revising. Arbitration and mediation must allow residents in the imbalance of wealth and power to have legal representation, expert witnesses. Fair rate of return process definitely should be had for the park owners. Vacancy control is very imperative, with vacancy decontrol where they can make that ground rent upon sale anything they want. Any application for more than an allowable annual increase requires the burden of proof to be on the park owner. I'm not going to go into the case law but it didn't really relate. In any RSO, legal fees as a standard are not collectible in an arbitration process. I say that because imagine the fair increase that just happened, where the park owners buried residents in 11 different methods, asking for $595 more a month, and receiving an award of just $4, and then trying to collect legal fees of $500,000 from the residents. It doesn't make sense. I did attach previously the Senate and Assembly bills that were notated, also don't really relate to what we're talking about. We offer that any RSO must be thoughtfully drafted, historical loopholes closed, give park owners a vehicle for proving loss or needed increases, and allow residents to be protected from severe increases. Almost every mobile park owner, including the large equity mobile park owners, have done due diligence before purchasing a mobile home.
Can you wrap up in maybe one sentence or two?
Yes. So they are aware of the profit before they buy. And we just ask that you give this due diligence to enact the rent stabilization ordinance. I would just really quickly want to tell you that in San Rafael, this was upheld all the way to the Supreme Court. Thank you.
Thank you.
Good afternoon, Mayor, council members, staff. Gary, great job with your presentation. My name is Denny Drosos. I oversee the operations of Rancho de Napa Estates. I appreciate the opportunity to comment on tonight's informational presentation regarding mobile home rent stabilization. I respectfully ask council not to move forward with rent stabilization ordinance unless the actual data demonstrates a community-wide problem that cannot be addressed through existing laws or more targeted solutions. I understand that this discussion was widely prompted by a dispute by one particular community involving the removal or separate billing of water charges that residents believe were included in their rent. That may be a legitimate concern, but it is fundamentally different from a pattern of excessive rent increases. California already has a detailed mobile home residency law, and the Department of Housing and Community Development operates a program for receiving and referring alleged violations. There is, therefore, an existing state process for addressing disputes regarding rental agreements, utility charges, and other management practices. A dispute involving one property should not automatically lead to a permanent regulatory system governing every manufactured home in Yountville. I encourage the council to closely review the rent histories at Rancho de Napa Estates and Bella Vista. Ask whether the numbers demonstrate rent gouging or an actual emergency. At Rancho de Napa Estates, our increases over the past 10 years have been modest and measured. Our average increase has been approximately 2.5% per year based on market rent, and our rents remain significantly below those charged by many comparable communities. We have not used our below market position as an opportunity to impose sudden or excessive increases. Rent stabilization can provide short-term predictability for existing residents. I understand why that sounds appealing. However, it can also create unintended incentives. When an ordinance establishes a maximum allowable rent increase, responsible operators who previously increased rents by less than the amount may begin taking the full allowance per year. They do so because they cannot know whether the formula will later become more restrictive or whether they will be able to recover future increases in insurance, payroll, utilities, maintenance, and capital improvements. I serve on the board of Manufactured Housing Communities of Oregon. I have watched rent regulations evolve over there. Oregon initially adopted a formula allowing 7% plus inflation. After inflation caused the allowable increase to reach 14.6% in 2023, the legislator amended the law to impose a 10% ceiling. Beginning in 2026, larger manufactured housing communities are subject to a separate 6% limit. The lesson is not that every jurisdiction will follow exactly the same path, but that these regulatory formulas can change considerably after they are enacted. Once a program exists, both resident and owners begin to plan around the maximum rather than the property's actual history and circumstances. There is also administrative cost. A rent stabilization program requires staff time, annual registration, fee collection, notices, record keeping, hearings, legal review, and procedures for owners seeking a fair rate of return. Those costs do not disappear. They are paid by the town, the property owners, the residents, or some combination of all three. Before creating that expense and bureaucracy, the council should first determine whether rent histories show a problem serious enough to justify it. At Rancho de Napa Estates, we believe assistance should be directed towards residents who truly need it. We have established a rent preservation program for financially vulnerable residents who qualify. The program can freeze future rent increases, provide stability while allowing the deferred amount to be recovered when the home is eventually sold. That is a targeted safety net rather than a blanket benefit for every homeowner, regardless of income, assets, or whether the property is the primary resident or vacation home. To simplify it, rent control doesn't work unless you put a cap on the sales price of a resident's home. Because if you don't, the new owner pays a higher price for the home up front in exchange for cheaper rent. After I spoke at the June council meeting, several Rancho de Napa residents approached me and thanked me for how the community is being operated. They also told me they did not support rent stabilization ordinance. Another resident advised me that a significant number of homes within our community are used as second homes or vacation properties. A broad ordinance would therefore provide the same benefit to financially secure second homeowners as it would to generally vulnerable residents. I respectfully ask the council to begin with the evidence. Review the 10-year rent histories. Compare current rents with competing communities. Identify whether excessive increases have actually occurred. Evaluate the existing state remedies and the targeted assistance programs already available. If the data shows modest increases, below market rents, and no pattern of gouging, then I ask you to consider whether Yountville truly needs a permanent rent stabilization bureaucracy, or whether the concern that prompted this discussion can be addressed directly and more appropriately. Thank you for your time and consideration.
All right, thank you very much.
Good afternoon, Council. My name is Salo, and I'm with WMA. We work with mobile home park owners throughout California, offering education, advocacy, training, and many other functions. I'm here today to urge you not to pursue the route of a rent control ordinance and to direct your staff to go in a direction that will better benefit everyone involved. Enacting a rent control ordinance would be immensely expensive, risky, and actually counterproductive to the goal of preserving this type of housing in Yountville. As you're aware, mobile home communities offer some of the last naturally occurring affordable housing in California. Unfortunately, this model of housing is slowly disappearing as zero more parks are built and more parks close every year. There are many reasons why this keeps happening. One of them is the proliferation of really onerous rent control laws in California. The owners of Rancho de Napa and Bella Vista are proud of the communities they have built and managed, offering hundreds of families a beautiful, safe, and affordable place to live. They want to continue to serve the people of Yountville for many years into the future. We're here today to make sure that they continue to do that. Our economy's recent challenges have been heartfelt by everybody, and both residents as well as management have felt and been impacted. We're sympathetic because we understand very well how much the cost of everything has gone up. Unfortunately for management, the costs of infrastructure repairs, sewage, maintenance, insurance, water have all risen significantly faster than the rate of inflation. Even so, managers take every step they can in order not to disrupt the lives of residents and to keep rents as low as possible while still being able to provide the safety and quality of life that residents have come to expect. Yountville is home to two beautiful mobile home communities with owners and managers who are actively involved and concerned about the well-being of their residents. The first thing a rent control ordinance would do is to permanently change the relationship between managers and residents, from one of partnership to an adversarial one instead. Rent control ordinances also carry huge bureaucratic costs and risks for lawsuits, as owners find the courts to be their only recourse in order to properly maintain their communities. So instead of doing rent control, sit down with your housing providers and let's come to an agreement. If the members of this council feel that there's a need for future assurances that rent increases will be low and reasonable, that goal can be accomplished in much better ways. We understand that local officials want to provide the same protections to mobile home residents as apartment residents receive from the state's Tenant Protection Act. But you can do this without creating an expensive bureaucracy that ends in an ugly mess of lawsuits and fair rate of return challenges like in Petaluma. because it keeps being brought up here. The characterization that none of these challenges have ended in high and unexpected rent increases for the residents in Petaluma is just not true. Any desire to bring here the nasty environments that exist there in Petaluma now just absolutely makes no sense to me. We've personally participated instead in MOU negotiations that have delivered immediate results for everybody involved. Peace of mind for residents while preserving our ability to properly maintain these communities. In fact, MOUs can deliver results that a rent control ordinance could not, such as the existence of rental assistance programs or no litigation agreements. We have recently come to such an agreement in Rancho Cordova as well as Sunnyvale, both of which are working very well for everybody involved. The ownership of both of these communities are ready to sit down and have this discussion with this council. This council can deliver much of what the residents are asking for without costing this town a dime. That's good governance. I urge you to take this path instead. Communicate to us a willingness to sit down, and let's get to work. Thank you very much for your time. I really appreciate it.
Thank you.
Hello, Mayor, council members. I'm Terry Bremer, and I live in Bella Vista. We've heard some interesting counterpoints today, and I don't envy you your job. Now you get to sort through it all. I do want to add a couple of points from our perspective as we, as residents, have gotten a better understanding of the MRL, which is the body of California law, part of the Civil Code. We've heard all that background that does cover the operation of mobile home parks and the way we live our lives since we've chosen to reside in them. My late husband and I came to Yountville in 2018, and we bought in Bella Vista Park. After the kids were gone, we sold the big house in Napa and decided we live on a single level here in lovely Yountville and be able to travel and chill. Well, I haven't been chilling last year since we've started to do our due diligence and learn more about what the law has for us. Initially, we were extremely grateful to find that Yountville had the foresight in 2010 to establish the senior overlay ordinance for both parks. That's my analogy is that that's the bottom piece of bread in our sandwich. We've got all the wonderfulness of Yountville in the sandwich, and now we're at the point where we can't have an open-faced sandwich anymore. We need a rent stabilization ordinance to be the piece of bread. And yes, it can be gluten-free if you want on the top, but it is Yountville after all. In recent years, I've noticed the town of Yountville changing, and I became very aware when I worked the census in 2020 how our town has changed from primary year-round principal residence kinds of homeowners to people who have second or third homes here and are here part of the year or not. We've seen that very same phenomenon in Bella Vista, and I hear from my counterparts in Rancho de Napa. I was kind of surprised they said more than half of the homes in Rancho de Napa are second or third homes. You've heard earlier that the MRL, I believe it's section 798.17, specifically exempts second and third homes or non-principal residences, might be fourth or fifth homes, who knows, from any application of a rent stabilization ordinance. And I appreciate your interest, and I'm sensing maybe a willingness to try to figure out how can we do that, how can we make it fair. If it's true, there are 319 manufactured homes between both parks, Bella Vista and Rancho de Napa. If it's true that more than half of Rancho are second and third homes, and there's at least 15 that I can count in Bella Vista that are second homes, that's like 133 units of the 319 in our universe that are second or third homes. So that leaves us with 186-ish, if these numbers are accurate. But getting to the right numbers would be something that staff could do and further study to really find out what I call the true facts. If we have 186 manufactured homes in Yountville that are principal residences of the people that live in the parks, that's who could benefit from a rent stabilization ordinance. And you say, well, you have the MRL. Isn't that good enough? No, it's not, because it prescribes notice requirements for rent increases, but it does not do anything about caps. And it says that with 90 days written notice, the park owner can give notice of a rent increase. So in theory, every 90 days, if that were the worst case scenario, we could have a rent increase. That's why we're interested in a rent stabilization ordinance, to have one rent increase per year tied to some objective, measurable standard. And it's true, I've done the math myself. My rent increases, except for the one mutant year when the whole economy was bad, thank you, COVID, my rent increases have been hovering around 4 or a little bit lower. But the RSO, as to rent increases, also bolsters the MRL because it could provide some structure to how do you set the base rent when a manufactured home changes hands. That issue is another big one that we've seen in neighboring parks, and we think that there needs to be some control for that. There is no control in the MRL.
Can you wrap up with one or two more sentences, please?
Yes. The third part, and I call it the third leg on the RSO stool, is to shield residents from what might be any unexpected pass-throughs of capital improvement costs to the park owner's asset. And so those are the three elements of protection that we don't necessarily have from the RSL, and that's why we're seeking a rent stabilization ordinance.
Okay, thank you very much.
Thank you.
Anybody left who would like to come up and speak to us? Once I close public comment, this will be a council-only discussion with the staff, so last chance. Seeing none, I will go ahead and close the public comment on this item and bring it back to council. More questions, thoughts? Councilmember Knight.
Mayor, thank you. Thank you. Thank you for all your comments and information. It's a complicated question. What I think, what concerns me is the issues of stability for Yountville residents, and then just the preservation of affordable housing. I mean, we're always addressing this, as some people have mentioned. We've talked about, and the concern in our community for years about the loss of primary residents in town to second and third homeowners. We've talked about it in the community, but we didn't think about that, about what the fact that it was occurring. It could very possibly be occurring and was occurring in the two mobile home parks, and so it's a question and concern that I have about doing what a council, how as a community we can do whatever we can do to preserve preserve housing and affordability in the community. So just a quick question for our town attorney. Your firm is a very well-respected municipal law firm. You must have a lot of experience in other communities that you probably serve in that have RSOs, and I was just curious maybe where your organization or your business serves and your experience with RSOs.
Sure, we do. We also serve in Novato. Novato has a mobile home rent control ordinance for its 4 mobile homes that are there in the city. It actually owns one of them, so the city is the owner of one of those homes, and that adds another dimension to that. So familiar with the ownership rules and also the ordinances and some of the familiar provisions that were noted here. We also occasionally defend in litigation as well, so familiar with that piece as well.
Thank you.
Are you talking about 4 units or 4 mobile parks?
Parks.
Okay.
Yeah.
You have
I do.
Councilmember
May I
Tripp?
make a comment?
Yes. Sure.
This is a tough one, and maybe more so because I actually have sat through a lot of the kind of issues that come up. I would say, just as a background, we have given a lot of time and effort to affordable housing in Yountville. As someone pointed out, we spent $900,000 planning, and I'm hopeful we'll be able to repurpose some of that for the affordable and workforce housing at the Commons. So we've made a big investment. I think in general, because I just feel it's so important, even though I'm going to speak to some of the bumps that come in the road, it's so important to support and assure continued occupancy for mobile home, manufactured home owners here in Yountville that I'm generally in support of a rent stabilization ordinance because of the real need. It is unsubsidized affordable housing, although right, when people start selling them for $500,000, it may not be as affordable, but we have a lot of people who've been here a long time who really do need the affordability component of this because it makes the difference between them being able to stay and then leaving. And then, of course, if we have long-term residents leaving, then we do get back into the problem of people, and you can't really argue with it. We have a beautiful place. They want to buy a second home here. That's hard to argue with. I guess my major comment would be the devil will be in the details. I would like to encourage the council to look into this further because the ordinance is very a lot. So if you look up in Calistoga, they allow rent increases. And again, this is just AI research. So if I have it wrong, I apologize. But in general, it's 100% of CPI up to a maximum, I think, of 6%. And they have around 600 units up in Calistoga. Now, Petaluma has a much more stringent rent control ordinance that allows only 70% of CPI or a maximum of 4%. So that's a big difference. So one of the problems I've seen with rent control is what can happen is because owners, was in the context of real tenancies in buildings, can't make needed improvements because there's no way to necessarily fund those. So I think it's very, very important that we, if we do go down that path after studying it further, have a very realistic ability for the park owners to keep up with the costs of maintaining the park. And so something, again, this is very preliminary, but close to CPI would be appropriate to me. I'm most interested in controlling the increase of rents on people who've been in the park. So I do like the idea that it wouldn't necessarily apply to second homeowners. But I guess the devil's in the details, and the only other thing I want to say is there really are 3 prongs in some of these ordinances, and they really vary. You have the rent adjustment part, you have the vacancy control part, which is a word for basically, at least in my understanding, if the unit is sold, does the park owner have the right to bring it up to something like market rent? And that is a way for the owner to get back in the game, shall we say, and keep the park well financed, because it doesn't do anybody any good to have a park that the owner can't afford to keep it up. So I would have to give some real thought to vacancy control. And the other element, the third prong that I've seen in some of them is just cause, when you can evict someone. And boy, that gets into a whole a whole bunch of issues, and I would hesitate to put that into our ordinance. So I guess, and then my final comment on it, I am generally in favor of it, is I also liked the idea brought up by Mr. I think Londano, if I said his last name correctly, of a non-regulatory approach through some sort of MOU, a memorandum of understanding, in other words. I would not be adverse to something that achieved the goal but didn't necessarily have to go into the regulations and create an administrative burden. And I do know that there's some cost involved in this and staff and whatnot, but given the amount of time and attention we've spent for affordable housing and the protection of people who are such a really wonderful, having a variety of housing is the key to, in my view, an interesting community, because you have a lot of different types of people, and I just think that's really worth maintaining. So the cost to me can't be ignored, but given our general resources and our desire to support affordable housing, for me, that's not the major issue. So that's really what I have to say about it. So I would encourage the council to consider at least looking into it further, either a regulatory solution or perhaps an MOU solution, because we are kind of unique. We have just 2 parks, so maybe there is another way to achieve our goal without getting into a whole ordinance.
Vice Mayor, would you like to make some comments?
Yes, I want to thank the residents of Bella Vista for bringing this to the town's attention. I have to say that I did meet with Terry Bremer and Jeffrey Lake before this, and it piqued my interest to look into it a little bit more. And I also think that as a town, it's our responsibility to look at the whole situation that is presented by the mobile home style of home ownership and affordability, because one of our housing element programs is to preserve naturally occurring affordability, and I think that
Need some more.
one of those ways is by protecting the mobile homes. When we're looking for support from our staff, I think it would be great to actually have a local stakeholders meeting to assess exactly what are the key interests on both sides and how that will translate into the best kind of ordinance that we could create. I actually think if we pursue this, that an ordinance is preferable, because one of the things that one of the mobile home park owner representatives was talking about was looking back on the fact that they hadn't raised rents very much over the years. But what I see is, looking forward, the playing field is changing rapidly. What we see more of is not local ownership of mobile home parks, but an influx of disassociated investors who see that mobile home parks are an investment worth pursuing and not necessarily having the local community in mind when they make those investments. So looking forward, it's necessary to make sure that we as a town are actually protecting, and it's an enforceable decision that we've made. So I would like to look into much more precise language and using any of the ordinances that have been cited or that the town attorney's firm knows about, so that we can preserve units. And in a way, I would like to also look into the way that the law or the RSOs don't apply to second home ownership. It would be interesting to know why and how that mechanism works, and make sure that we're not missing something, because that's a pressure that we feel in the entire town. And if the lowest priced homes are in the mobile home park, we're going to see increased pressure there, because that's a bargain. And doesn't matter how much money you have, you love a bargain. So if they're buying for a second home, it doesn't reinforce our community very well. So I think it's on us to ask those questions and find out what our best path forward is, and always looking forward rather than what has been or what we used to have. So so the cap, the pass-throughs, the increases, 1 per year, all of those things seem reasonable, and it sounds like the park ownership would like to be reasonable. So a stakeholder meeting could establish that reasonability, and we can work through more questions, because I think we're just scratching the surface here. And I also don't think we want to take forever to do it, because I think the pressure is real and it's current. So I would like to see it come back to us as soon as we can.
Councilmember Knight.
Thank you, Mayor. I would just say that I agree with the comments from the Vice Mayor and Councilmember Tripp that I think it's wise for us to move forward on a discussion, research and discussion on a RSO, rental stabilization ordinance. And I come from it primarily because I think we need to look forward, and we need to look at what the town or the community can do to preserve affordable housing in this community. And as we've said, it is an unsubsidized affordable housing, but the changes that have been occurring all over this community, and they're also occurring in the parks, is that this transfer of homes from people that live here primarily as their primary residence, and coming here and expecting to live here their whole life, to properties that many have become second and third homes, investment homes, where that changes the nature of a community. And we've seen that all over Yountville, that when we're out as elected officials knocking on doors and talking to residents, and when we're basically only talking to folks that live in this community as their primary residence, like every third home or something like that, then there's a loss to the community. So I think we need to consider the concerns that the residents of both the parks have brought to us. I also met with Ms. Bremer and Mr. Lake, and I think they've given us information that I think the town should consider should continue to research and bring something back to council. And I think the Vice Mayor's suggestion that we include stakeholders, the owners of the park, I think for a discussion is appropriate. And let's, if we can, then we'll set up a meeting for all to sit down and to talk about how we can preserve affordable housing in this community. So I'm ready to move forward with staff working on this. And I understand it can be time consuming, but I think it's something we should, as the Vice Mayor said, move forward with sooner than later.
All right, so thank you, the rest of the council, for your comments. I'll give you mine. I, too, met with Ms. Bremer and Mr. Lake, just for full disclosure. We had a great conversation. Thank you for providing your background materials. They were helpful. I would call myself a good friend with Ella Gates. I never met her husband, Thurman, who actually started Bella Vista. It was known as Gateway Mobile Home Park. The stories that she had when her husband and her came here in the late 50s to develop the park are one for the books. So I actually created a video of a conversation we had. So it's actually on our YouTube channel. It's if you ever wanted to, if you didn't meet her and you'd like to, go there. She was quite a lady. So I think I do also agree that this is something we definitely want to look into. I guess my first overall question that I really have, and thank you, Gary, for talking about the general applicability law. I don't understand it. I don't really know how we're going to deal with that, but what I see is that maybe one park would like this and one park wouldn't, and maybe we'd have to go into the general applicability law to figure out if we want to put it on one and not the other. I don't know, but it seems like that's probably the real 30,000-foot question I really have if we want to do this. How is that going to work if both parks don't feel the same way? Also, I'm very concerned about the second home owners because these parks are, as everyone else has said, very important in terms of affordability. And I do not want to lose them, not just only for that, but it really adds to our diversity here in Yountville. And I think that's why they need to be protected. And I want to make sure that we do come up with the right solution because the last thing I want to see is one of the owners saying, well, I'm just going to put this up for sale. So really, I think taking some time, and maybe the stakeholder meeting is the right way to do it, to really figure out what the issues are, get some background information, how much has rent gone up, what are the true problems, because I can't solve something unless I really understand what we're trying to fix. So that would be number two in terms of how we kind of move forward. Also, the whole thing about this conundrum about how you provide a release valve to give a fair and reasonable return. Do we need a study? Do we have information? How do we go about that? That's something that I think is kind of going to be part of the crux of all this. I know there's a lot of examples we can use, and maybe that's where we go because we won't be able to figure it out either. But trying to get some information there is important. Also, again, further information if we, do we include or not include some information about all the staff time and the recovery of fees. It just, right now, hearing things, it sounds really expensive and something that we'll have to figure out how to pass through and make sure that everybody, if we do this, you really understand, like, well, yes, now your rents are stabilized, but you've got to pay your local government to make sure that all happens. So I want to have a much better understanding of that. So anyway, those are my initial comments as well. So I think what we're all asking is that, we'd like to see it move forward in terms of whatever this end result is that we're going to get. But I think some more information is going to probably help get us there. So were we clear enough that you have just 1 second. Are you clear enough so far what we've kind of told you about? You guys, I'm sure you can take all these notes and then put them together and come up with something, but do you have questions for us before we get one more comment from Councilmember Tripp?
Well, from my perspective, I think we've got enough feedback. There's a couple research questions here, which we'll do, and then stakeholder meetings, investigate the need for the ordinance, gather some more information. Is there anything else, Ken, in your notes you want to add?
Okay.
Then I think we've got the direction.
Okay, Councilmember Tripp, question?
So I wanted to ask Attorney Bell, and a couple people have mentioned that well, we only have 2 parks, and there could be different situations in both, and hence the question about could we regulate one and not the other, which don't know. That sounds like a real invitation to litigation, personally, but just because people don't like to be treated differently who are right next door. But my question is, have you seen, I really like this idea, and I hope people won't disregard, sort of just throw this out as a possibility of some sort of a memorandum of understanding with the parks about, especially because that allows you a lot more freedom in some ways on both sides to target the actual issues and maybe not use a sledgehammer for a mosquito if that turns out to be the situation. I really agree with everybody who says more facts are needed. So now that I've gone on at some length, my question is, have you seen that happen? And what does that look like? Because that was a new idea to me because I also met with the proponents of this and also had a chance to talk to the Mr. Londano and about their views of this, and I think that's a really interesting idea and somewhat creative. So my question to you is, have you experienced that? What does it look like? How? Yeah.
Yeah, so the concept is essentially a contract between the town and the operator, the owner, to comply with certain requirements that might otherwise be in an ordinance. I think the practical issues are if there's a breach, town would have to sue to enforce it. What are the damages from that? Is it the town's damages? Is it the residents' damages? So you have a remedies issue that could come up. You could create third-party beneficiaries, I suppose, in the residents there and allow them to sue under the contract, even though it's only for in between the town and them. So I think the big issue would be enforcement, right? If it is breached and not followed through, what do you do, right? If it's in your code, it's a violation of your code, you can fine, you can, go seek an injunction and you could theoretically do some of those things under the agreement too. So it would not have the force of law. It would be an agreement, and then you'd be operating under contract law for your enforcement. So that's the big difference, I think.
Have you seen that happen? Have you worked on any of those? Or
I haven't seen one in lieu of an ordinance. Okay. I suppose they exist, but I've seen them as settlements, right? So there's an issue there, an enforcement issue that's going on, and then you're entering into this to comply with something that's alleged to noncompliance. But perhaps others in the room have a more detailed.
And then I'll stop because I think Ken wants to say something which would probably be very helpful. But as you already alluded to, if there is a problem, even with an ordinance, typically the city or town is going to get sucked into the litigation, usually anyway, right?
Well, it depends on what the problem is, right? So if the town is acting as a decision maker for disputes and there's a town hearing officer that's issuing a decision, then yes, that decision is what would be challenged in court and the town would be named as a party, definitely. If you are engaging in code enforcement, so if you have an ordinance that's more passive that says here's what owners have to do but doesn't really have a dispute process that comes to the town side, you'd be issuing fines and code enforcement and declaring things nuisances like you do for your other code provisions. You could be sued over that as well. Of course, it's just a different process.
Well, so I was just in my mind comparing the lawsuit risks. It's kind of sad. That's how we have to think. The lawsuit risks of an MOU versus an ordinance, and they both have risks. So anyway, thank you.
Town manager.
Thank you, Mayor. I was just going to suggest that if the park owner representatives in the audience have examples of MOUs that work for your or might work for your respective parks and organizations, it'd be great to have you send those in so we could look at them.
Okay. All right. With that, staff has plenty of direction. And before we move on to item B and bring back Councilmember McKee, I am going to, let's see, it is 5:20.